School violence has become a national concern, with the safety of teachers and students as the focus. The Texas Code of Criminal Procedure sets forth requirements for peace officers to notify school officials about the arrest or referral of students for specific offenses to aid administrators in maintaining a safe learning environment. A law enforcement agency or a person who refers a child younger than 17 to the juvenile court or arrests an adult older than 17 who is a student for any felony offense or for a misdemeanor offense of unlawful restraint, indecent exposure, assault, deadly conduct, terroristic threat, engaging in organized criminal activity, unlawful use, sale, or possession of a controlled substance, drug paraphernalia, or marijuana, certain weapons offenses, or finally, the unlawful possession of any prohibited weapon is required to take certain actions. First, in situations involving a juvenile younger than 17 or an adult older than 17 and the previously mentioned offenses, the officer shall attempt to determine if the child or adult is enrolled in a public or private elementary, middle, or secondary school, commonly known as high school. If the child or adult is determined to be a student or the peace officer is unable to confirm but believes the child or adult is a student, the law enforcement agency head or designated representative shall verbally notify the superintendent or the designated representative of the student's school district within 24 hours after the referral or arrest or before the next school day, whichever is earlier. Once the law enforcement agency has made the notification to the superintendent or designated representative, that person is responsible for notifying faculty and staff of the school as appropriate. Within 7 days after the date the verbal notice is given, the law enforcement agency head or designated representative shall mail written notification marked personal and confidential on the envelope to the superintendent or designated person. The written notification must include the facts contained in the oral notification, the name of the person who was orally notified, and the date and time of the oral notification. Both verbal and written notification shall contain sufficient details of the referral or arrest so that the superintendent or designated person may make administrative decisions on the continued attendance of the student at school. While it's important to keep schools safe, our system also recognizes it's important to protect the privacy of the student who was arrested or referred. A person who receives information under this article of the Code of Criminal Procedure may not disclose the information except as specifically authorized by this article. If a person intentionally violates the disclosure statute of this article, they commit a C misdemeanor. The Code of Criminal Procedure states oral or written notice must include all pertinent details of the offense or conduct, any assaultive behavior or other violence, and any weapons used in the commission of the offense or conduct or weapons possessed during the commission of the offense or conduct. In addition to this information, a law enforcement agency shall provide any information regarding the student requested by a school superintendent or his or her designee in order to conduct a threat assessment or prepare a safety plan related to the student. Finally, failure of a law enforcement agency head or designated representative to complete notification will be reported to the Texas Commission on Law Enforcement.